On January 21st, 2010, in Washington, D.C., the court case regarding Citizens United versus FEC took place. It falls under the category of election issues.
I wanted to run commercials against Hillary Clinton during the 2008 election, but it was not allowed because it violated the BCRA, or the Bipartisan Campaign Reform Act. I believe the BCRA goes against the First Amendment and restricts my freedom of speech. We believe that government spending is a form of free speech.
These are the rules regarding the amount of money that can be donated or used for or against a candidate in the election, and they cannot be broken. The BCRA states that corporations and unions are prohibited using Treasury funds to advocate for a candidate.
I rule in favor of the Citizens United and agree that the BCRA violates the First Amendment. The government can no longer legally keep corporations or unions from spending to slander or support candidates.
This is a landmark case because the ruling was very unexpected. Many were supported because it upheld free speech. It was widely celebrated in the political world because it meant that more money could be spent on campaigns and the support of political candidates.
On June 30th, 1971, in Washington, D.C., the court case regarding New York Times versus United States took place. It falls under the category of civil liberties.
The United States thought we, the New York Times, would hurt national security by publishing the Pentagon Papers, although I disagree.
I believe that the government should restrain the New York Times from publishing these papers. They are compromising the Vietnam War by doing so. Not to mention, these papers have been stolen from the government.
I rule in favor of the New York Times and agree that the government cannot prevent the New York Times from publishing the papers.
This is the landmark case because the Supreme Court upheld the idea that the government must provide a significant amount of evidence against the New York Times before it can restrain the company's freedom of the press.
On January 18th through 19th, 1973, in California, the court case regarding Miller versus California took place. It falls under the category of civil liberties.
I sent out pornographic magazines and was arrested and charged with a misdemeanor for knowingly sending out obscene material. I disagree with the charges against me, especially because in order to be judged obscene, materials must be utterly without redeeming social value. Also, I believe that I should be protected by the First Amendment.
Miller violated the law based off of previous obscenity cases and is found guilty in Orange County by the state of California.
I rule in favor of the state of California and believe that the sale and distribution of obscene materials is not protected under the First Amendment. Although state statutes designed to control obscenity laws must be regulated in order to keep cases like this.
This is a landmark case because it offers a more specific definition of obscenity and what falls under the guidelines of illegal.
In 1999, the court case involving Attorney General Janet Reno versus American Civil Liberties Union took place. It falls under the category of civil rights.
The ACLU challenged provisions in the Communications Decency Act of 1996 that criminalized providing minors with obscene materials via the Internet. We argue that the provisions of this act go against the First Amendment and our right to freedom of speech.
I agree with the ACLU and rule that the provisions of the Communications Decency Act of 1996 do in fact undermine the purpose of the First Amendment.
This is a landmark case because it first brings the relevance of the First Amendment to the Internet age of society.
March 9th, 1964, in Washington, D.C., the court case of the New York Times versus L.B. Sullivan took place. It falls under the category of civil rights.
I, L.B. Sullivan, a city commissioner in Montgomery, Alabama, sued the New York Times over an advertisement placed by the committee to defend Martin Luther King and the struggle for freedom in the South for libel. I also claimed that this advertisement was attempting to defame him.
Restricting what the New York Times can or cannot print in their newspaper is going against the concept of free press, as well as the First and 14th Amendments.
I rule against Sullivan and the Alabama Supreme Court. The Alabama libel laws are too broad and go against the right to free speech and free press.
This is a landmark case because it was the first time the U.S. Supreme Court limited a state's authority to award libel damages based on individual state laws. It also defined actual malice as a national standard for determining libel cases involving public figures.
On March 9th, 1964,
You're holding it upside down.
in 1999, the court case involving Attorney General Janet Reno versus
I sent out pornographic magazines and was arrested and charged